All right, the matter we're going to address is the matter of People versus Luis Alberto Reyes Rios.
El juez está diciendo que van a hablar del caso de Alberto Reyes Ríos.
Is that you, sir?
Yeah.
¿Es usted, señor? Yes.
Sí.
I met you at the time of the plea. The matter was set for sentencing this morning.
Dice que la condena está programada para esta mañana.
Once again, our interpreter is here with us.
Una vez más, nuestro intérprete está aquí con nosotros.
Pablo, I know you're not in the driver's seat, but I'm not doing this in a moving car.
Okay, I'm going to stop. Can you give me a few minutes?
As a point of fact, I don't like doing anything from a car. It's like an inconvenient nuisance instead of a matter of importance. And all the time I have people appearing from cars, defendants, lawyers, others. I would rather do it from a fixed point, but I don't do anything with a moving car, even if they are the passenger. I don't want to have an accident while we're handling a case. All right, are you at a fixed point?
Yes.
All right. This is file number 251494OD. People versus Luis Alberto Reyes Rios. Mr. Reyes Rios was charged with operating while intoxicated in the village of White Pigeon. That was on July 27th. He is here with his lawyer, Mr. Timothy George. The White Pigeon Village attorney is not present. The defendant had a very high blood alcohol level, and he pled to the charge of operating while intoxicated, and a charge of no valid operator's license was dismissed. Daniel Frazine from the probation department has prepared a pre-sentence report, and we're going to refer to that now. Mr. George, what would you like me to know?
Your Honor, this was obviously a very scary situation. When you have an individual with this blood alcohol level, it's fortunate that no one was injured or killed. I have had the opportunity to review the recommendations with my client. And as part of this process, I was able to learn that there were some prior alcohol offenses out in the state of California.
Y revisamos su historial y vimos que no hay ofensas del estado de California.
Your Honor, I understand that there are a lot of bad facts as it relates to this situation. However, I do think it is important to have this defendant on probation so that he can have access to services. When an individual has prior history and this high of blood alcohol level, it's clear that he doesn't have his addiction under control. While I understand why the probation department is recommending what they're recommending, we would ask the court to consider that my client currently is responsible for the care of 2 young minor children of his girlfriend. She is present and advised me that she picks my client up from work and drops him off at home to watch the kids while she works. My client currently is employed out at Nagel Farms out on Michigan Ave. While that is seasonal, he indicates that he's still on call. We would ask the court to consider a jail sanction within the scored guidelines of this case, with the probation, including the services as listed in the report.
Mr. Reyes Rios, is there anything you'd like to tell me?
Pues solo que considere eso, que yo soy la única persona que cuida pues a mis niños cuando.
You have to speak in short sentences.
Solo que
I would like to, Your Honor, to consider I'm the one who's taking care of those 2 children.
soy la única persona que puede cuidarlos cuando mi novia se va para su trabajo. No hay ninguna persona que los cuide.
I'm the only one who can take care of the children when their mom goes to work. There is nobody else to take care of them.
Y también ella es la única persona que me puede llevar al trabajo y también va por mí al trabajo para no perder días de trabajo y también para poder cuidar pues a los niños.
And the mother of my children is the person who's taking me to work and bring me him back, and so I wouldn't miss any work, any jobs.
Eso es todo.
That's it, Your Honor.
Mr. Friesen, you've recommended just a flat jail sentence, is that correct?
No, Your Honor.
No, and other probation.
Yes, Your Honor. When you look at the case facts, for the drunk driving in California to initially on a first drunk driving to give him a 90-day jail sentence says a lot, because my experience has been that they're pretty light on first-time drunk drivers. And even though that was a house arrest, it was a jail sentence, which it was revoked for a new drunk driving roughly a year later. And here we are again with a very high drunk driving and a disoriented driver blocking a roadway and could have caused a serious accident. When you look at the escalating sentence factors, we are limited to 93 days. And he's already had well more than that on his last drunk driving. Honestly, I was thinking a straight jail sentence, but I believe that it would be better for the community to give him some services as well as a sanction. I would just like to point out that I don't think he takes this stuff very seriously.
No, I didn't get that impression either.
Especially when he showed up an hour and a half late for his appointment with me. And after numerous disconnections, he eventually just hung up on us because he had to go. I would completely understand if the court just gave him the 93 days and no probation. However, my recommendation is 60 days credit 159 to be served in the courtroom with a 24-month probation, Your Honor.
This case is aggravated for several different reasons. The defendant has no driver's license. He was convicted in California in 2017 for drunk driving causing a bodily injury. He was placed on probation and he got another drunk driving within a year, and he got 140 days in jail.
Lo meten 140 días a la cárcel.
He also refused to take the test in that case.
Él se niega a tomar el examen para detectarle alcohol en ese caso.
He was again driving without a valid license in our county in March of 2025. In this case, his blood alcohol was 0.341.
Su nivel de alcohol en la sangre era de 3.5.
He was very, very intoxicated.
Él estaba muy intoxicado,
very disoriented,
muy desorientado.
And he thought he was going to pick up his children. He was going to drive children like that. He also refused the breath test again. He was very casual about contacting his probation agent. It is also likely that he will be deported for this.
Es muy probable que lo deporten por esta ofensa.
I don't want him on probation. He doesn't take this seriously enough. I'm going to order 61 days in jail, credit 1 day, leaving 60 days to serve.
I believe he has a question or something.
Yes, sir.
No, cuando me llamó el oficial del deputado condicional, yo estaba trabajando donde no había señal y se cortaba cada rato. Cuando recibí la llamada de la persona,
You have to
A ver,
speak in
espérame.
short sentences.
cuando
When I was talking to the probation officer, I was working and I didn't have very good signal, so the call was cutting off on and off.
cuando en la corte, cuando estaba aquí en en la corte pasada, yo les expliqué aquí en la ventanilla que podría ser cuando me llamaran en mi trabajo, podría ser que yo estuviera trabajando donde no tuviera señal. Y me dijeron que
Short.
And I explained here at to the clerk that I probably was gonna be working when they called me, and it was probably that I wasn't going to have a very good signal.
What else?
¿Qué más, señor?
la persona que me atendió me dijo que estaba bien, que si no entraba la llamada, que me podría dejar un mensaje de voz para que lo escuchara cuando tuviera señal.
So the clerk told me it's okay if you are having problems, leave a message and there won't be a problem.
Eso es todo lo que tenía que decir.
That's all that I had to say.
All right, thank you.
Muy bien, gracias.
Which is all the more reason why it would be difficult to put you on probation. The fine is $0 because that's money away from your children. There's $125 of state minimum costs, a $100 screening fee, $150 attorney fee, and a $200 police reimbursement. That equals $575 or 10 additional days in jail. It is probable that you may be deported for this. That's not up to me, that's up to the Immigration Service. I want to spend my own money and get some billboards in Spanish. Say, don't drive drunk or you will get deported.
No maneje borracho o lo van a deportar.
There's really nothing more to say.
Y ya no hay nada más que decir.
You have a terrible alcohol addiction, which you don't have under control.
Usted tiene una adicción al alcohol terrible y no está bajo control esa adicción.
Which would be a reason for probation.
Lo que sería una razón para que tuviera usted libertad condicional, ¿no?
But you didn't do anything between July and now to deal with it.
Pero usted no hizo nada entre julio y hasta esta fecha para lidiar con ese problema, ¿no?
Except to keep drinking.
Excepto seguir tomando alcohol.
All right. The sentence is 61 days, credit 1 day.
Muy bien, la condena son 61 días de cárcel y le estoy dando crédito por un día de cárcel.
There's 5 days a month good time credit.
Le voy a dar 5 días le van a dar 5 días de crédito en la cárcel.
Which would make 50 days.
Lo que serían 55 días de cárcel.
You have to pay your $575 before you're released or do 10 additional days.
Tiene que pagar $575 o se queda otros 10 días en la cárcel.
If you are deported, then it doesn't really matter.
Si usted es deportado
and the person whose fault this is
y I'm sorry, Your Honor. There is somebody else talking. I don't know.
All right, the person who is at fault for this
La persona que tiene la culpa de esto
is you.
es usted.
You can go with the officer.
Ya puede usted ir con el oficial.
¿Puedo darle mi cartera a mi esposa?
Can I give my wallet to my wife?
Yes.
Sí, sí puede hacerlo. Thank you, Your Honor.
Thank you, Pablo.
I'm sorry for the mishap today. I
All
apologize.
right, well, Vivian offered to come in, but I said we already had you booked, so we had a little mix up, but we got through it.
My pass in the car. She have the passport.
All right, we had an emergency matter. I tried to do at 9 or 10:45, which I should have known better. We got sideways for a couple different reasons. And that is in the matter of Caleb Evan Stainer. Mr. Stainer, we're right in the middle of lunch hour. Try to get you back to it. Mr. Stainer is presently in the St. Joseph County Jail. He had previously posted a $2,000 10% bond and a charge of domestic assault. It was a condition of his bond that he not have any contact with the complaining witness in that case, and her name was Mariah Baldridge. He also was not to use any alcohol or engage in any assaultive or threatening behavior. He got arrested early this morning, about 12:30, and it came to my attention first thing this morning. He has an attorney pretrial set for next Friday, December 5th, on this charge with attorney Ross Truckee. Mr. Truckee was scheduled to be here, so I attempted to schedule this before we start out our other sentences. Anyway, Mr. Truckee is here, and Angelique Campbell is here from the prosecutor's office. This is very troubling information. If the information is correct, you went to Miss Baldridge's house in violation of the order, assaulted her, fought with the cops, and are facing some new charges. Ms. Campbell, do you have any input on this?
Yes, Your Honor, I do. As a matter of fact, the defendant has been charged with additional offenses by Mr. Robar from my office this morning pertaining to the conduct alleged last night: home invasion in the second degree, aggravated stalking, interfering with a crime report, and another charge of domestic violence. It is very pertinent to note that at least after speaking with both the defendant and the protected party in this matter, the officers did see new, fresh injuries on her consistent with the version of events that she provided. And again, what the court's already stated is most concerning is that this is in violation of a protective bond for a pending domestic violence charge, where she again is the alleged victim and the protected party. He did have a 0.24 preliminary breath test, although he stated to the officers he felt he was only a 3 on a level of 1 to 10 for intoxication. It's extremely concerning. She's not safe when he is on bond. He is violating this court's orders blatantly, not only contacting her, but committing new alleged offenses, injuring her, and then additionally consuming alcohol as if the court's order makes no difference to him. I think that it is necessary to set at this point, I request $100,000 cash or surety bond, or even a bond revocation. We've got new serious felony offenses pending as alleged from last night, and a protected party who is not safe when he is in the community.
Mr. Truckee?
Mr. Stainer would deny all of the allegations in the bond report and enter the equivalent of a not guilty plea to any kind of contempt proceeding.
All right. Thank you. Is your other guy here on the plea?
Mr. Ghost is also here.
Okay, good. This next matter is People versus Brandon Lee Chafee. Mr. Chafee's from Indiana, and he's been here for every proceeding. Charged with having a high blood alcohol level and possession of a firearm under the influence. The high blood alcohol level charge was dismissed, and he pled to operating while intoxicated and possession of a firearm while intoxicated. Ross Truckee was appointed to represent him, and Mr. Truckee is here today. Also present is Angelique Canfield. This is a county prosecutor case. Matt Huff prepared the screening report in this matter. I read it last week, but also the first thing this morning, I understand there may be an addition to it, so I'll take a look at it. Mr. Truckee, what would you like me to know?
Mr. Chaffee's been extremely open with me regarding his need for treatment. He is engaged in therapy services related to anxiety and childhood trauma. Part of the issue we have is Mr. Chafee kind of blocked out some things from childhood and decided to address them this year and made a confrontation to a family member that had mistreated him, and that's kind of let the genie out of the bottle. I think he's sorting all of that, and it led him down a road here where he's drunk at Purgatory and kind of having a not so good time by himself. He had a girlfriend, has a girlfriend. She was there with him. She called it in, asked that officers come assist. By the time the police get there, he does cooperate with them. You know, he's just an emotional mess. He's processed in, he gets bonded out. And made a contact with me immediately, sat down in my office. We had a nice long talk about the situation. I understand he was very participated fully in the investigation with Mr. Huff. Reports that he exceeded the normal time that's taken there because, again, Mr. Chafee's an open person. We acknowledge the issues that Mr. Huff would provide update on that have occurred since entry of the plea. And while the court always hates to see recurrence, sometimes that recurrence can tell you just what the problem really is. So I'd ask the court to consider Mr. Chafee's openness and willingness to participate in treatment. He is hopeful for a sobriety court sanction in Cass County, which I think is the right answer for him long term to get through this drinking mess. So we would ask court to consider scheduled jail time as well as Mr. Chafee. One of the strengths he's got is a job at AM General that he's held down for a while now. So we'd ask court to consider those options. Thank you.
Ms. Canfield, do you have any input on this case?
Oh, Your Honor, it's concerning and sad altogether. The defendant does have mental health concerns. He has been and may continually be suicidal from time to time due to a lot of things. But he definitely is alcohol dependent, and even somebody who isn't a professional can see that. With respect to the number of offenses that he has, this would be, according to the criminal history, his fourth in, well, about 13 years. There was a reduction in 2012 from a drunk driving, and then 2 subsequent arrests for the same behavior while on bond for this offense. He doesn't care about himself right now, so subsequently he doesn't care about the law either. But it's becoming a risk to society in addition to himself. I know that he's been placed on probation in Indiana. They're looking to place him on probation in Cass County. I don't know whether they will or not, because that would be duplicative of Indiana's efforts, and that's where he resides. But again, we have another person blatantly ignoring this court's bond conditions and pretrial orders, post-conviction, but pre-sentencing. And I think that we need to seriously take that into consideration when looking at an appropriate sentence. If he's getting services in other communities and states, doesn't reside here, I don't think probation would be appropriate here. And the only alternative I can see to that as a sanction is a punishment and a deterrence to others for this type of behavior. He has possessed firearms, intoxicated while driving continually for 3 times in the last several months. It just can't be ignored. And he's doing that. So I'm going to ask for, I know Mr. Huff recommended 30 days. Frankly, I think 93 is appropriate. And I would ask the court to sentence to 93 days. And after he has a pretty significant period of sobriety, he can then begin his services in the other states and deal with his other cases.
Mr. Chafee, is there anything you'd like to tell me?
Yes, Your Honor. I know there's no excuse out there for what I've done. I take full guilt for what I have done, but like my attorney, Mr. Truckee, has stated, I've had a bad year this year with my mental health. It all came to a head earlier this year, and that's when I was clinically diagnosed with severe anxiety, severe PTSD from severe childhood trauma in my life that, lasted for over 10 years. And then I held it in for over 20 years. And when all this anxiety and stuff, it just came up and all this, kind of flooded into me once, or I was faced, instead of like trying to face these things, kind of one by one and fix things, it was all flooded to me at once. I immediately went and sought mental health treatment for it, and I am currently medicated too for it. It's just the alcohol. It's not that I wasn't drinking to have fun or to because I had to. It was
You're drinking to kill the pain.
Yes, it was, with my anxiety, I get really bad overthinking and my head just goes crazy. And it was to quiet my brain down to help me just, relax and everything. And the way my therapist has put it is, she actually said she's surprised things ain't worse with me because of how traumatic of a past I have. And that how it came out. And, I get, the me on paper and all this stuff does look really bad for me, but, this, honestly is not the person that I am. I am actively working on getting myself better. I'm going to see my therapist more often now than I was. I'm looking to, I'm going to be getting enrolled in UA class in Bologna at their Bologna Baptist Church there for treatment. Plus, my pastor and his wife have also offered to do spiritual based counseling for me too, to help me out and just overall get everything better for me.
Well, there's a lot of walking wounded adults out there who are carrying around childhood trauma. In fact, almost everybody I see is carrying childhood trauma and deal with it not very well as adults. There's a whole new school of thought in aiding judges in trauma assessment when imposing sentence. Lord knows I've seen plenty of trauma, but this is bad. Now it said in here, you acknowledge you'd been in an accident earlier in purgatory. Was it on the same day or an earlier day at a different time?
That was as a few months beforehand, I was out driving and the alcohol was not related at all. It just, the road give out and was loose and my truck slid off to the.
Well, purgatory ain't on the way to anywhere. Osceola's a long way from there. You just came there because you wanted to get in a very rural area.
Yeah, just out in nature, quiet place to, clear my head and,
My fear is you went out there to commit suicide.
That is not the case at all.
Well, I'm glad it wasn't. Your girlfriend got worried about it. But then this was on September 14th. You got arrested again on November. Well, I don't know when you got arrested. You got convicted in Cass County on November 24th, and you got convicted. Then you got sentenced the next day.
He was arrested on November 2nd for that Cass County case, and he pled at his hearing on Monday.
So he was on bond on November 2nd when he got arrested here on September 14th.
No, September 14th was starting it off. November 2nd.
Oh, November 2nd. I'm sorry.
And then November 14th was the incident in St. Joe County, Indiana.
Well, in a classic case of government not what was going on, Osceola County didn't realize you had two other, or fifth Superior Court. I'm not sure what jurisdiction that's.
St. Joseph.
St. Joe
Indiana,
County.
South Bend.
That you had two drunk drivings pending, and they gave you this probation with a suspended sentence. Judge Renfro didn't know you had that one or this one. It's likely that Judge Renfro may put you in jail on December 18th, but there's a consequence. And in two of the occasions, you had a gun. So they took your first gun and then you were out there again with another gun.
Your Honor.
Yes.
For the Cass County, I was transporting the firearm to my mom's from my house. And when the accident happened, it came out of the case and was out, and
Well, it probably would have been fine if you hadn't been drunk and then there was an accident.
Yeah, it was, but yeah, it wasn't on my person. It was all
right.
over transportation.
Which is fine, except you were intoxicated. I'm gonna order 0 fine, 1 day in jail credit, 1 day on the possession of firearm. Firearm is forfeited. Eventually, there's a consequence, and that's today. I'm gonna order 31 days in jail. Credit 1, leaving 30 days to serve.
Is there any way this can be scheduled jail time, Your Honor?
No, you're going to jail right now. There's a consequence for your continued drunk driving. You're gonna lose your job, unfortunately. Judge Renfro will know you're in our jail at the time she does hers. Yeah, eventually it catches up with you, and it just did. We don't pat you on the back and say, hey, please don't do this anymore. The sentence could have been 93, which is what the prosecutor thought was appropriate. No, there's a big, heavy load that just landed on you.
Your Honor, dude, I don't know how my mental health ain't gonna. I don't think we'll hold up for that time. Being in there like that.
Well, I will connect you with the services we have at our jail, but you got arrested for drunk driving with a gun twice and 3 times drunk driving in about 30 days. You should consider this.
Related, Your Honor. I mean,
and I see it all the time. That isn't a get out of jail free card.
I'm not asking for it to be, but I'm asking for mercy in the court to help allow me to get the help that I need, and jail is not allow me to get
I won't disagree with that, but it's a matter of punishment and protecting society. I'm gonna let Cass County or St. Joe County work on your treatment. This is just plain punishment and protection of society. You can go with an officer. Fine is zero. Once again, $75 crime victims' rights fee, $50 state minimum fee, $100 screening fee, $150 attorney fee. There was no police reimbursement requested. $375 due by March 1 of 26. I'll send this envelope. Yes, nobody wants to go to jail. I don't blame you, sir, but you earned it. Paul, he gets this too.
Mr. JP, I'll contact Cass County so they know, because your hearing is set for December 18th. I'll make sure they know what's going on, and then I'll contact South Bend too, so they know.
Would you let Lauren Frank know at the jail also?
Yes, I will.
We'll try to get some mental health services in addition. Oh, there was some bond there. $200 of bond. It was $175. I don't know the facts of the accident in Cass County, but I'm glad somebody didn't get killed. Ms. Campfield, the other matter we had in here was a scheduled plea. We kind of got sideways with our time here, but we'll address that. Friday is going to be another Friday, December 5th. Very busy.
Yes, Your Honor. I believe that Ms. Stoll has reviewed the files and is in the process of sending out offers if she hasn't already. And then, is Mr. Strainer being arraigned this afternoon on the felony?
I don't know.
Okay.
Theoretically, if the paperwork is here, the magistrate will see him.
Okay.
He's not doing well. I have sobriety court this afternoon, but because of all the other stuff that got said in here, including two difficult things between 1 and 2:30, I don't have time to do the staffing. So we're just gonna go in cold.
I'll speak with Mr. Truckee about Mr. Ghost.
All right, well,
Should
I'm
be
ready
ready
if
to
he
go.
is. We often don't get a full lunch on Monday when I do with Ghost. Good afternoon, sir. Are you Caden Jesse Ghost?
Yes, sir.
Mr. Ghost, you're charged in this complaint with disturbing the peace. That's a certain kind of statute. They didn't charge it on a disorderly person. They charge it as 75170, which is disturbing the peace in a public place. I say this a lot. It doesn't matter who was right or wrong, who started it. Was there a disturbance in a public place? Your lawyer says that you were intoxicated, so you don't have a clear memory of the incident. I do have a bond report which I can use for the facts. If you do plead no contest to this matter, you'll be giving up your right to have a trial. Do you understand? There won't be a trial. Do you understand?
No, sir, I don't.
Well, if you plead no contest, there won't be a need for a trial. By pleading no contest, you don't admit what happened, but you also don't deny what happened. And you would allow or accept that a conviction would enter. So are you willing to plead no contest to this charge?
Yeah.
All right, anybody threaten you to get you to plead no contest? Did
What's that?
anybody threaten you to get
No,
you to
no,
plead to
no.
this? Or promise you anything? You have to speak your answer.
No one has told me, sir. No.
All right, excuse me. So let's talk about this. Do you understand that if you do plead to this charge, there won't be any trial? I'm going to give you a fine and complete the sentence. Do you understand?
Yes, sir.
All right. If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckee is here to represent you. He has also been appointed. You could have also hired an attorney if you wanted. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court. So they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. Do you understand?
Yes, sir.
And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. All right. Can I use the bond information report that was provided?
Yeah.
Some people would concur with that. Your
All
Honor.
right, thank you. On November 6th at about 9 o'clock at night, they were at Little Caesars in Sturgis. And a guy called, his wife apparently got into it with you over your driving. And she said, stop driving like a jackass. And then somebody said, hey, bitch. And then you got out and had a black gun in your hand. And they provided a description of you and the car. And then they found you. And there was a little bit of a scuffle there. And they searched the vehicle and found a gun. It's one of this thing get charged with more than this. You did spend 4 days in jail. There's enough facts in there for disturbing the peace. Do you remember what you were drinking?
Fireball, sir.
That'll do it. All right. Normally in disturbing the peace is do a time served and a fine. I'm also going to forfeit this gun.
It was a airsoft or something. It had been dressed up, just so you're aware, Your Honor.
Don't bring an airsoft gun to a real gunfight. Police will shoot you.
Well, Your Honor, what was concerning here is that the handgun had been the airsoft gun was painted black to look like a real handgun, and it did have live ammunition in it.
Yes.
So could have been a very bad situation that could have resulted in his being killed by the police in some type of a shootout if they really deemed him to be a threat to themselves or the public. He also was a .11 PBT and wouldn't comply with the officers. So,
But you didn't get charged with drunk driving. You didn't get charged with felonious assault. You didn't get charged with brandishing a firearm. You didn't get charged with any of the other stuff that could have accompanied this. So I see why Mr. Truckee wanted to get in and get this plea in the can. But
Well, Your Honor, can I say something?
yes, sir.
So I'm going through a program too. I don't know if you know. I'm getting on the bus at was at 8:15 tonight to go to a program.
Good. Which one?
It helps the better. It's called Good Samaritan. I think
Okay.
it's in Texas. But yeah, had a bus ready for me at 8:15. I was gonna head down there and that was gonna help line my life up and fix me.
Well, is that still the plan?
Oh yeah.
All right. That's a good plan. All right. 4 days jail. Credit 4 days. $75 crime victims' rights fee, $50 state minimum fee, and $150 attorney fee. This $75 fine, that adds up to $350. You posted $100 of bond. I mean, $250. Probably warmer in Texas than it is here. They could do by next year, so that you get situated down there, March 30th of 2026. Mr. Ghost, this seems like a better plan than some I've heard. You can come get this. The bailiff left me when they took those guys into custody and went to lunch. I wish you good luck. How old are you?
I'm 20.
Well, this is a good time to address this stuff. You're gonna end up like the last two guys who are not doing well at all. All right, sir, you're good to go.
Thank you, John.
Thank you.
Thank you, Frank.
Jason, take care of yourself, young man. Get on that bus. Go to
I
Texas.
appreciate it.
Good afternoon, Mr. Lambden. Thank you for being here early and on short notice. I'm gonna get right to it. I have a very busy afternoon today. I had to cancel my my sobriety court staffing for this, which I didn't want to do, but thank you for agreeing to appear on this short notice. It's titled Centerville Mobile Home Park versus Shauna Zerley. File number is 252106LT. Shauna Zerley is here with me in the courtroom. She emailed, I wouldn't exactly call it a court filing, and she hasn't paid a filing fee. She emailed a motion to stay eviction and motion to set aside judgment, motion to stay execution of judgment, motion to set aside vacate judgment, on a number of things in an email. She then also today dropped off a bunch of stuff to the clerk a short time ago, which she's still trying to get date stamped and scanned in, so I haven't seen it yet. I wanted to try to address this before Thanksgiving, which is why I crammed it in here. The defendant is here in pro per. Legal aid will not be representing the defendant. Megan Bauer told me or us that she would not be representing this defendant and that they did not accept her as a client. So she's in pro per. We had a first hearing on November 7th. We had, me being the court, had some confusion about how much was actually due. There were issues about how costs were calculated, what were late fees, what were utilities. So we rescheduled the matter, as we always do, for a second hearing, and that was heard on the 14th of November. And the parties were placed under oath, and I took testimony and came up with a figure that the amount owed. This is a demand for non-payment of rent, not termination of tenancy. I found that the amount owed was $2,752.69, $169.84, and cost for a total of $2,922.53, I think it is. And the date for the writ theoretically would have been Monday the 24th. I wasn't here on the 24th or 25th. As I indicated, it is a non-payment of rent case, and it allows removal of the trailer. The defendant has filed a bunch of stuff, not paid the motion fee, and asked me to stay these proceedings. We took testimony on the 14th, as I indicated. Both parties were sworn. And it was actually a lower figure than before. So the defendant has raised a number of issues here that I don't think were raised before. Ms. Zerley, what are you asking me to do?
Well, their math isn't mathing. I did make two payments that I was ultimately told by them that did not go through, but they did go through my bank. So I ended up paying them, and I don't have the paper in front of me, so I don't have the exact figure. It was over $2,000 some, which leaves me a credit of $100 for the month of November. And there's in their system, when I sign on, it even shows that, and it shows that I made the payments also. I did include some of my bank statements also. There's a lot in there, and I'm sorry, I try to keep it minimal.
Well, We took testimony under oath. Ms. DeCenzo is here and the manager, Jessica, is also here, Jeshua. Ms. DeCenzo's testimony was no payment had been received, I believe, since June. There are often issues with these new payment methods where they can only pay through a payment portal and you can't go give cash to your landlord anymore, and it costs you a fee to actually pay your rent.
And it cost me several fees to pay.
But I don't believe that you made several $1,000s worth of payments that you weren't credited
Their
for.
records even show it, like the bills that they dropped off on my door. And they didn't apply the accounts to my account. And the thing that's really disturbing to me is I tried to get a hold of Ms. DeCenzo yesterday. I think I missed her call. I have 2 portals that I can log into. One of them shows that I didn't pay and the other one shows that I have paid. Now, why I have 2 different portals from them, I have no idea why. But they're completely different login information. She did have me set up a new account. I think it was in August when I did pay. I paid August 8th and I think it was 14th possibly.
Your Honor, if I may, we're covering old ground here.
Yes,
This was argued on the 14th. As was noted on the 14th, there were 2 payments that were made and returned NSF. And you noted that as you calculated the amount due. As far as today is concerned, obviously I didn't have an opportunity to get a response in, and I haven't seen whatever was dropped off this morning.
neither
What
have
I
I.
would-
It's a big
yeah.
pile of stuff that has been handed to me about 2 minutes ago.
And so what I would say is, firstly, if there's a motion for stay, it should have been accompanied by 1 month's rent as a bond. If there was no filing fee paid for the motion, I'm guessing there was no month's rent deposited with the court. I would also indicate that what this seems to me, at least in part, would be a motion for reconsideration. And for that, the tenant defendant would have to show that there was a palpable error on the part of the court. And looking at what was sent by email, I did not see any kind of palpable error. She argues that she was somehow entitled to a public defender or legal aid to represent her, and I think we've established that certainly was not going to happen. In addition, she's making the same argument, it sounds like this afternoon, that she argued on the 14th. I would indicate to the court that at the time that the court entered the judgment and noted the payment deadline of the 24th, it indicated that it was not likely to sign any kind of order of eviction until probably December 1st, just because of the way the holiday broke. And in fact, with this motion having been filed, we have not yet submitted the order of eviction to the court. We're prepared to send it in as early as today, but the court's not going to get it or look at it until after the weekend. So there is still time for Ms. Zierle to move without having an extra month's rent added to her tab. I think the court handled everything properly on the 14th. It took extensive testimony from Ms. Zierle. It evaluated it. It credited her for some money that had been assessed because it felt that the late fees were too high. Therefore, the judgment amount was less than the amount that was showing on my client's ledger. And I see no basis at this time to revisit anything that the court did on the 14th.
May I speak?
Yes.
But you haven't seen what I have and neither has he. I don't feel that I had another person to back me up as I needed. And I felt like I got railroaded. And I feel like what I do have needs to be looked at and it needs to be considered no matter what was decided on the 14th. I did state when we first started that I filed that I needed some help because of an ADA accommodation. And that was under oath. And
I looked for that. I
things
couldn't
to
find it,
stop
but let me,
at that point.
this is a matter of paying your rent or not paying your rent.
Yes.
It's not an ADA. They're not terminating your tenancy for just cause. There are certainly accommodations we make for people with.
I just needed help speaking for
right.
myself.
Okay, I'll concede that. We had 2 hearings, lengthy. I blocked out a bunch of time. I knew it was gonna take a long time. Then immediately after you file all this stuff like throwing spaghetti at a wall to see what'll stick. You didn't pay a filing fee, you didn't file it properly, you just emailed it to the court. Now, you're not a lawyer. So this morning, like an hour before the hearing, you drop off all this stuff. It's your contention, you're not under oath. And I said, I don't believe you, but you're not under oath, that you've paid all the delinquent rent and you should actually have a credit.
It shows on the paper,
All
on their
right.
paperwork.
Show me in here, you find it, show me where it says you paid your rent.
When you look at these two. That's those credits up there. They were never applied to my account. They're just keep showing up and showing up and showing up. And here's the bank statement. And this is showing, it shows up like this when they've received a payment for showing that I have a credit of $100 and some as of now. Even when I log in, like it won't let me even pay anything if I wanted to online. But I circled a bunch of things for Christy and I sent them back to her and I was like, it shows.
Then have a seat.
So there was 2 different things that happened with my bank.
Well, sit down,
Okay.
sit down. All right, Ms. DeCenzo testified under oath that they haven't received any money under any account since June. And I agreed with that. I substantially reduced the amount they were asking for by reducing late fees and some other things that were unclear. And I came up with that number after taking testimony. The way the trial works is you don't come in 4 days later and say, well, here's all the evidence I should have had at the trial. Plus, I can't make head nor tail of it.
I entrusted for Meg
All right,
to,
so they want you to move your trailer. And I suspect you've done absolutely nothing to move your trailer. So what you want them to do is take your money and let you stay there.
they already have my money.
All right.
I can't go anywhere. I'm halfway dead as we speak.
I don't believe they do have your money. And I would need someone from the bank to testify, not just some papers that are printed off a screenshot.
I didn't pay because I knew it would come to court. I didn't pay for 2 months and then I ended up paying and she told me she hadn't received my payment. And then she did get my payment and it shows. And it's even on all the bills they put on my door that they received that money. But then all of a sudden they come up with all this money that they need me to pay. And if you look at all the paperwork, you'll see where they just.
I don't see it. I see
up.
where it's so small, I can't read it. It's a screenshot from something.
It's from their account
Um,
where I log in online.
I can't even read it. All right. So you're asking me to do a number of things. You're asking me to stay the proceedings because your contention is we haven't seen this evidence that establishes that you've paid the rent. We took testimony that you haven't paid the rent. In fairness to Mr. Landman and Ms. DeCenzo, they haven't seen any of the stuff that you laid on me at 11:45 this morning. And so I can't tell what it shows. I suspect when Ms. DeCenzo goes through it, she's not going to change her current opinion.
She's not.
That you owe the money. And the point of fact, they didn't do it as a just cause termination. Would have been a lot easier if they had. I mentioned that last week, and there's no reason to beat a dead horse. And he's right. Nothing's going to happen till after December 1st. We've never actually, I haven't seen one of these that's been executed. Let's say they hire a company, Kramer Trailer Moving Services. They come up, they disconnect your gas, your electricity, your water, and then they pull the trailer off your lot. I don't know what they do then.
I've tried
Take it to
move
Walmart parking lot and park it?
I tried to get help to move because I don't want to be there because of the things that have.
Well, that's the other stuff. You told me what a terrible place this was and how much you hate being there and
But
you're
I'm already
unsafe and you've
half
been
dead. I don't
assaulted.
see any point in trying to move right now. I don't know how much longer I have.
Well, none of us do. Anyway, I haven't signed any eviction order. Oh, you came in at 12:50, not 11:50. You came in at 10 minutes before the hearing and laid all this paperwork on us. I did set this on short notice because I wanted to deal with it.
In all fairness, Meg had this on the 7th and I thought she.
Meg
was
is not going to be
I
representing
thought
you.
was
She
going to show you
indicated that
guys that.
she was not going to be able to establish an attorney-client
She never told me
relationship and
that.
they would not be representing you. And she wasn't here at the hearing. They don't get court-appointed counsel for civil matters. Maybe it'll come at some point, but it'll be extraordinarily expensive. We don't have enough coverage for criminal matters where people are in danger of being incarcerated. If they have court-appointed counsel for civil matters, we're talking billions of dollars. So we presently aren't there. But nothing is going to happen imminently. Mr. DeCenzo, Ms. DeCenzo, I don't know if you guys have contacted a company and I don't know what they're going to do. You're doing nothing. You're doing nothing.
I don't know what I'm supposed to do.
You're supposed to find some place to move your trailer to. You hate it there. You don't like them. You feel they're unfair. You believe you were
They need to
assaulted in
be
your own
audited.
home. And you'd like to move, but you haven't done anything to find out
No,
about
I
moving.
haven't. I don't have the energy to move. I don't have the energy in me to fight anymore. Okay?
Well, the money that you claim that you've paid, which they contend you have not, could be used to pay for the move of your trailer.
Yeah, I could. I've tried to get the county to help me move it after what's happened to me. And
Well,
they've heard of no such thing.
I've never heard of the county paying.
So they
you.
want me to move no matter what.
Well, ostensibly, yes, they do.
Well,
Now,
she has called me several times and tried to get me to sell it before we even came to court.
now that in the other ones, there's an option. You have 90 days to move or sell the mobile home.
Well,
And so
it's-
very often they work out some sort of an agreement where you sign the title over to them, they forgive the arrearages, you don't have to move the mobile home. And then, in fact, I think that's usually what happens.
It's unfair to make me leave.
Why?
I'm not the problem. A lot of things keep happening to my home. It keeps getting broken into over and over and over and over. I'm not the problem. They're aware of who the problem is and they're not taking care of it. So I find it unfair and unfit that I am the one who has to move. Just because someone doesn't like me and they're causing a lot of problems.
Well, they argue that you're not paying your rent and you haven't paid the rent since June.
They've destroyed my trailer.
Well, they haven't.
I would rather pay a lawyer than pay them. Because I know I paid and they know I paid, and I don't know why they're doing this. Other than the fact that I feel like it's retaliatory. Just like my garbage can gone, just like my rent keeps going up, knocks on my door, asking me where I'm getting my medication now, the day that I change it to a different pharmacy. Why would they need to know that? Because my medication keeps getting stolen out of my home. Like, this stuff is just ridiculous. These are the things that I've been dealing with. I don't want to be there, but I can't move my trailer. I'm not going to move my trailer. I just want to stay and I want to be left alone. And I want things to be fair.
Your Honor, if I may, my client is willing to discuss with Ms. Zierle either purchasing her home or accepting a transfer of the home in exchange for a waiver of the rent that's owed. But under either scenario, Ms. Zierle is going to have to move. And what would likely happen if an order of eviction were issued is that the first thing that would occur is that with the assistance of a court officer, Ms. Zierle and her belongings would be removed from the home. My client would have 56 days from the issuance of
No,
the
they
order of
wouldn't.
eviction.
No, they wouldn't. They would not be removed from the home.
I'm too old for this.
You have the right to move the trailer. You do not have the right to remove anything from it. So you've got all kinds of liability issues here by doing it this way. No, she doesn't have to move out. Under a just cause, she does. She has 10 days to vacate and 90 days to move or sell the mobile home, but you didn't do it that way. So you have a right to haul the mobile home off of her lot. And she doesn't have to vacate. She doesn't have to move anything out of there. Under the other way that nobody does, she would. Now, again, here today, nobody's under oath. We were last week, and Ms. DeCenzo testified and no money had been paid. So essentially, she's arguing the same thing. At 10 minutes before the hearing, she filed a bunch of pleadings that I can't read that contends that she's paid the rent.
And that puts us in the same position as we were on the 14th,
Yes,
Your
we
Honor,
are.
because you concluded
So,
that her payments had been returned to NSF, which is in accordance with what had been testified to by Ms. DeCenzo.
NSF can also be considered a credit. That needs to be looked at.
No, it isn't.
Pay lease
No, it's
and rent
not.
manager.
So
both
that's
tried
your,
to take from
that's
me.
your contention that the NSF should be credited to your account?
That's not what I'm saying. NSF. Now, NSF can mean they tried to pull from rent manager and from pay lease. It only pulled from one. So it got returned to pay lease, but not rent manager, if that makes any sense. They tried to pull it twice through the portal, and I'm not sure exactly why. My paperwork does show that, and it does show where it was taken, and it shows that I was actually charged by rent manager to pay that payment, both of them. The amount in the $1,118.11 and the amount in the $1,228 and some odd cents.
Yeah, we took testimony on that matter on the 14th.
I know you did.
And I didn't make that finding. One option I'm considering, Mr. Landman, is
You can see in the paperwork that I paid.
I can't see anything in this paperwork. I can't even read it. You filed
Well,
it
then you
10
need
minutes
bigger
before the
glasses. I
hearing
don't
and it's so small, I'm gonna need to magnify it to read it. Plus, I don't know what it means. I'm not an accountant. I don't know what the bank's policies and procedures are. It needs an expert from the bank that can tell me what happened to this money. I'm contemplating setting a hearing and entering an escrow order where she has to pay December and November's rent, which is money she could use to move. November's rent is long past due. December's rent is about to be due. What's that?
I'm fine with paying November and December.
But I already made a finding. Multiple problems. Mr. Landman spoke to these. You didn't file a proper pleading. You sent an email to the court.
I asked
You
how to
didn't
do it.
serve a copy on the other party. We had to do that. You didn't pay the filing fee.
I'm okay with
For
doing that. I'm not
for
a
that.
lawyer. I had nobody to help me.
I know you're doing the best you can. But I already did it. And I resent the fact that I had to cancel everything I had that was scheduled for this afternoon to
My
hear this a
apologies.
second time because you didn't like what I ruled the first time. Mr. Landman, one of the problems is she's filed all this stuff. I could simply say it wasn't timely. It's filed 10 minutes before the hearing starts and she didn't
I
serve a
was told
copy on
that's
the
what
other
time I needed
side.
to come in. I did what I was told. I was told to come in 15 minutes early.
Well, yeah, that's
you could get
fine,
that
but not
paperwork.
come in 15 minutes early and file your
That's what I was
pleadings.
told. I'm sorry.
All
If I
right.
was told differently, I'd have done it differently.
Mr. Lamon, any final words?
Your Honor, all I will say is that even though that Ms. Zierle is representing herself, she is still obligated to do things in compliance with the Michigan court rules. The court certainly had the discretion to expedite the hearing, and I appreciate the fact that it was trying to deal with this promptly. But as far as a basis, certainly as a basis for setting aside the judgment, there is none. And there's really no basis for a stay either without a bond having been paid, without the filing fee even having been paid. I think this was simply a situation where Ms. Zierle was attempting to buy time, and she succeeded to an extent. Even if as I mentioned before, even if the order of eviction were submitted today, you're not going to see it until Monday. And what you choose to do with it at that point, what the court chooses to do with it is obviously up to the court's discretion. But as you have noted, Ms. Zierle is unhappy living there. She wants to continue living there, I guess, for free, and she should.
I'm not trying to stop anything.
Stop. It's his turn to talk. Go ahead, Mr. Lamon.
Yeah, and that's really all I have to say, Your Honor. I think under the court rules, she hasn't met the conditions for reconsideration. She certainly hasn't met the conditions for setting aside or for a new trial. So where she's left is that she would have, or if she's running out of time or has run out of time even to file an appeal in circuit court. So I think that this was sort of a Hail Mary type of situation, and I don't see where the Hail Mary should be completed for a score.
I had a case recently where the case was being appealed from district court to circuit court, and they asked for a stay. And the circuit court said, ask for the stay in district court. It's like, I didn't want to stay it. I wouldn't have, you can ask for a stay in the circuit court. All right.
I don't want to go, and I'm not trying to stall any time, and that's not what this was about. I thought I had someone to back me up in court. She had all my paperwork, and then when we returned the 14th, which I had spoke to her before the 14th, I thought she was going to be there with my paperwork to back me up. This is not me stalling. This is me trying to be fair and try to get a fair judgment.
And by she, you're talking about Meg Bauer
from
Legal Aid?
And I'm trying to do everything within the court's judgment and whatever you want to call it. I don't know the proceedings. I don't know what they are. I'm not a lawyer. All I've done is call and ask questions and try to see what I need to do. And I'm still lost as that goes. But I don't feel that I should have to leave. Their math is wrong. And I don't appreciate getting threatening phone calls from her either. And I don't know if you read that or not. And I'm not making that up.
Well, since I didn't see it until 1 minute ago, I guess I didn't see it. Who made threatening phone calls to you?
She did. She was laughing.
She who?
Miss DeCenzo.
As of when?
Before court. Before the first hearing. They kept calling me like 3 weeks before court, asking me why I hadn't left yet, telling me I needed to sell, and if I didn't do this or that, they were gonna, I'm not gonna repeat any of it out loud.
Well, and one factor, you need to be able to speak to each other. Mr. Landman's suggestion is that you would somehow transfer title of this to them and move.
I don't even know that I have it. I'm not sure whose name it is anymore because all that stuff was stolen out of my house. I don't even know if my car's in my name anymore. To be honest with you.
All right. Motion to stay is denied. Motion to set aside the judgment is denied.
Which I guess in child kindergarten terms, I'm gonna need you to explain to me what that means.
Means they're gonna move your trailer off of there unless you agree to move it or transfer it to them.
So
They
I
cannot
can't
move
say.
you out of the trailer. They can't have the sheriff come move you and your stuff out. This isn't that kind of an order.
So I'm
is an order
essentially
to
gonna be homeless because I can't get a loan and I cannot get help. I've already tried to do all of that. That's cool. Happy Thanksgiving.
Perhaps. Uh,
She told me she would do this to me and she would make sure that that happened.
My goal isn't to make you homeless. My goal is to try to follow the law. And they filed this, they filed all the proper procedures. I'm allowing to do this, as I indicated. I wish they'd done it differently, but I gave the order that I gave. I took testimony under oath. Legal aid is not representing you. They indicated then, they've indicated since they will
And
not
I
be
also told you I
filing an
needed
appearance in
help.
this case.
A lot of times I see you, oh, I think you might need a lawyer for this. You didn't even offer me that. I don't know what I'm doing. All I know is I paid what I paid and they are trying to get more out of me than what I've paid. They're trying to get me double. And if you look through the bills that they personally gave me themselves and hung on my door, it literally says I paid them.
Well, the sworn testimony was no payment has been made since June of 2025. And that's the finding that I made.
I paid in
And I
August.
greatly reduced the amount owed. I believe their version more than I believe yours.
It's not a matter of whether you believe me, it's what is on paper there in front of you.
I
And
don't want to argue about it anymore. You're gonna have to
I can't
prepare.
even make a payment.
You're gonna
I
have
have
to.
a credit of $100.
I did not make that finding.
All the paperwork is in front of you. I don't enjoy, the only reason why I haven't paid them is because I paid them twice. And if you look through that fudgery of clown paperwork, it's not funny. Like, I don't know why they're trying to do this. Jesus knows, or Jessica, or Jessie, or whatever you want to call her. She knows I paid. I know she knows. I know she knows I got it. I'm concerned that they should do an audit on the whole trailer park because I guess I'm not the first person this has happened to. I've even asked her how much my rent is supposed to be because I think I'm paying a ridiculous amount of rent for living there opposed to other people. Why is that? Why don't I have a garbage can? Why was mine taken away and nobody else's? Like, this is just all retaliatory.
All right. They prevailed on the 14th, and I stand by that original ruling. I'll do an order, Mr. Landman.
Do you want me to submit one, Your Honor, or is the court going to do it?
No, I'll prepare one.
Very well.
So your options are to move your stuff out and leave your trailer there. Move your trailer to somewhere, or negotiate some sort of sale or transfer to the park for
Yeah, they offered me $500 in my keys.
I don't know the answer to that. I don't know how much the trailer's worth. In fact, I don't even know if you have the right to transfer the title to it.
I wish you would take the time and just really look through that stack. I know that you are.
I've made my ruling and I stand by
You
it.
did, and you made your ruling on the 14th, and I told you at the beginning of that I needed help. I had filed an ADA for a reason.
You didn't file
I cannot,
an
I
ADA.
did, and I did before that court date, and I told you under oath, and at that point, all proceedings should have stopped.
For what?
It's part of the law. It's part of my rights.
All right, then you
And
can appeal this to the circuit court and ask for a stay there. I don't think he'll grant one. They don't want you there.
I don't
If
want
you
to be
had a
there,
big
but
pile of money, you could pay it all.
I probably have a year left.
Well, here's one. I told you how much you owed. Pay it.
I'd rather pay a lawyer and have them look at that stuff than pay them.
Well, that's up to you. I told you in clear English that through November, now shortly, December will be due. I told you after hearing, $2,752.69 in rent and a court cost of
I paid
$169.84.
in August. I had $3,000 in my
All
account
right.
in August, and then I paid him, and I
Well,
have like
then-
500 left.
You owe
Where'd it go?
$2,922.53. Mr. Lamon, she gave all this stuff to us at 10 to 1. We scanned it. I'll send it to you, but
Your
please
Honor, that's
escort
not
Ms. Lilly.
necessary. Your staff already has done so.
All right, thank you. That's the cure. Pay it. All right, you're good to go. I'd
Thank you, Your
suggest if
Honor.
you want to stay there, you pay them rather than a lawyer. Of course,
But it
December's rent.
sounds like I paid them and I'm still not staying.
Well, if you pay them, you get to stay. That's pretty straightforward. Just under $3,000 through November. If you pay them rather than a lawyer, then your rent is current. I made a finding on how much the rent was due.
Well, I'm willing to bet that.
All right, please escort her out. I don't have
I
anything
don't know
else
how
to say. I don't want to
Can I
argue
get my
about the same thing.
paperwork
over
back?
and over.
Is what I want to ask.
Well, you file it with the court. We did scan it, so I guess I'll give it back to you. Show that it
I
was,
mean, I didn't make a million copies of everything. I'm not violent. There's no need.
All right.
I just want to
You're
know if
free
I can
to
have my
go.
paperwork back.
Thank you, Your Honor. Have a happy Thanksgiving.
all right, thank you.
Well, Ms. DeCenzo is waving her arms and she's muted.
I
That
apologize.
was not a good answer to that question, but that's my ruling and I'll stand by it. And I wish you would consider filing termination of tenancy, wrongful, just cause terminations in these cases that make our life easier.
The problem,
guys
Your
can-
Honor, is that in order to fall under the just cause statute, when the tenant is behind in their rent, you have to have filed on them 3 or more times in the course of a year.
Yes, 3 times in a 12-month period.
Right.
That's the
So-
way everybody used to do it.
So that
And
if the
that's the way
tenant is
some
2 months,
judges-
if the tenant is 2 months behind, for example, you'd have to file on the tenant, and you can't file as a just cause, so it has to be as a non-payment. And you have to do it 3 times in a 12-month period.
Yes, I'm aware of it, and I'm
Yeah.
aware some judges won't let you do it. You can't do this in, you can do it in Kalamazoo. You can't do it in Livingston. There are some other jurisdictions that say the law isn't clear. And I said this before, we need a change in the court rule, a court case, or a change in the statute to make it more clear. But so far as no one's appealed this. But your remedy is untenable. You have a right to come take her trailer off of there and move it somewhere, in which case you incur all kinds of liability. If you break the stuff that's in her trailer, you leave it somewhere and it gets looted. It's not a good solution to the question, but all right, that's my first crisis of the day. I've got another one here in just a minute.
You
All right,
have
I'll
my
see you next
condolences.
All right, thank you.
Where does that leave us? Sorry.
You can
Your Honor.
discuss that with your lawyer.
Okay.
All right, thank you. All right, that was not a very satisfactory ruling for anybody, but I made my ruling on the 14th and I believe it was accurate. And I don't believe the defendant has had her account dinged for the amount she claims. So we'll stop the live feed. We have a PPO matter, which I do not live stream. There's a federal statute that says you're not supposed to.
Next case is State of Kansas versus Lori Leanne Christie, 25 CR 494. And hello, Brad.
Hello, Judge.
Is Lori Leanne Christie present there? There may be, okay, I see on the monitor at apparently home, Lori Leanne Christie, hold up your hand if you can hear me, okay? Good afternoon.
Good afternoon.
Miss Christie, you are charged in 25 CR 494 by way of amended information. Count 1 on or about July 28, 2025 in Butler County, Kansas with theft, a level 9 non-person felony. This is currency of approximately $22,000 with the intent to permanently deprive the owner, El Dorado Swim Club, of the possession, use, or benefit of said property or services of the value of at least $1,500, but less than $25,000. Count 2, you're charged on or about July 1st, 2022 through June 2nd, 2025 in Butler County, Kansas with theft, once again, a level 9 non-person felony of currency of approximately $21,000 with the intent to permanently deprive the owners, to wit, El Dorado High School Wildcat Booster Club, of the possession, use, or benefit of that property or services, value of at least $1,500, but less than $25,000. Then you're charged on or about April 15, 2024 through June 2nd, 2025 in Butler County, Kansas with theft, once again, a level 9 non-person felony of currency of approximately $23,000 with the intent to permanently deprive the owners, El Dorado High School Band Boosters Club, services value of at least $1,500, but less than $25,000. Count 4, you charged on or about June 13, 2025 through August 13, 2025 in Butler County, Kansas with currency in the amount of $1,750 with the intent to permanently deprive the owner, USD 490 El Dorado Public Schools, and that once again is theft, a level 9 non-person felony, the amount being within $1,500 and $25,000. In count 5, you're charged on or about June 30, 2025 in Butler County, Kansas with computer crime, and that was in regards to creation of a receipt 0006132 for $1,750 on a computer for the purpose of devising or executing a scheme or device with the intent to defraud or obtain money, property, services, or other thing of value by means of false or fraudulent pretense or presentation. And that is, once again, a computer crime, a level 8 non-person felony. And those are the charges pending against you. Ms. Christie, do you understand the charges?
Yes, Your Honor. I only knew about 3 of them, but yes.
Okay, so now you've been charged, I believe, in 5 counts. Let me double check. Yes, 5 counts. And you do have the right to counsel if you cannot afford an attorney. One would be appointed to represent you. And are you currently employed?
No, I am not.
Do you have any money saved back to hire an attorney?
I do not.
Based on your lack of financial wherewithal, the court does appoint Jim Watts to represent you at all stages of the proceedings. Jim Watts is appointed to represent you at all stages of the proceedings. The court sets your next appearance date before myself, and that would be on the felony preliminary hearing control docket for Monday, January 5, 2026 at 2:30 by Zoom. Monday, January 5th, 2026, 2:30 before myself by Zoom. You do need to be present by Zoom process at that time.
Yes,
The
Your Honor.
next item of business is to set appropriate bond for you. What is your current address, Miss Christie? And how long have you lived at that address?
25 years.
Okay. Do you have any family that reside in Butler County, Kansas?
I have my mother, and I have a sister, and I have my in-laws, and I have my sister-in-law.
Thank you, Miss Christie. recommendation from the state in regards to appropriate bond.
Your Honor, given that the fact that the defendant appears in the fashion that she does today, the state has no objection to the court ordering an unrecognizance bond in this matter, subject to all standard conditions, with special emphasis on no contact with any victims or endorsed witnesses. Page 3 rather of the amended information appears to include an endorsed witness list that is quite extensive. The state would be recommending at the very least an amount of $10,000. Besides the 5 felonies currently before the court, the state's information is that the amounts alleged in the charging language of counts 1 through 5 appear to be approximately $70,000 in the aggregate. Additionally, the state would be recommending under the alleged facts of this case that it would be appropriate for the defendant to be ordered to not manage the money of any organizations during the pendency of this case.
Thank you, Mr. Regier. The court does adopt the recommendations of the state. I believe that was for a $10,000 OR bond, and that is the type and amount of bond that is ordered. $10,000 on your own recognizance bond. Court orders you to abide by the conditions as set forth by the state here on the record today. And Miss Christie, do you have any questions?
I'm sorry, can you explain what the OR bond means?
The OR bond means that you need to sign a bond. I'm going to check with Brad. Does the court security wish for her to check into the courthouse and to sign that bond off?
She's going to have to go to the jail and get processed, Judge.
Okay, thank you. You need to go out to the Butler County Jail to be processed. I'm not ordering a cash or surety bond. It would appear to the court that you have stable residence, you have family, and this is your first appearance and you have appeared. So I do not believe it is necessary for you to post a cash or surety bond, which would involve you coming up with either the cash or hiring a surety to act in your stead. So you'll be able to sign your own bond, but you will need to go out to the Butler County Jail, and I'm going to say you need to get that done because of the Thanksgiving holiday. It would be best that you get that done by 3 o'clock, by 3 p.m. on next Wednesday, December 3rd, Wednesday, December 3rd, 2025. Now, you may go out to the Butler County Jail anytime before that. You can go out today, but your last point in time that you're able to execute your own OR bond and also go through the booking process of the Butler County Jail. Brad?
I was just saying, Judge, if you put me in a breakout room, I can schedule her a time to go out to the jail and get processed.
Brad, thank you. I think that'd be helpful. And Miss Christie, I'm going to put you in to a breakout room with court security, and Brad will assist you in getting a date and time to be booked into the Butler County Jail. You'll be able to sign your own bond.
Thank you, Your Honor.
Anything further? Did you put down that next date before myself?
Yes, Your Honor, January 5th at 2:30 by Zoom.
That is correct. Very good. And Mr. Watts is appointed to represent you. His office is located directly across from the Butler County Historic Courthouse on Central.
Thank you, Your Honor.
Yes. Anything further, Mr. Regier?
No, Your Honor.
And Belen, I'd ask if you could put Miss Christie and Brad into a breakout room. That would be helpful. Have a good day.
And Your Honor, this is Bruce Idris I have here at the courthouse.
Thank you. Case is entitled State of Kansas versus Bruce Idris. Mr. Idris, you are charged on or about November 12, 2025 in Butler County, Kansas with permitting dangerous animal to be at large, a Class B non-person misdemeanor. This is in regards to a male pit bull breed dog named Thor. And Mr. Idris, That is the only charge pending against you. Do you understand the charge?
Yes.
You do have the right to counsel if you cannot afford an attorney. One would be appointed to represent you. Are you currently employed?
Yes.
Okay. And are you able to afford an attorney if you so desired?
Yes.
Based on information obtained from Mr. Idris, the court does not appoint counsel, and the court finds Mr. Idris does have resources to retain counsel if he so desires. The court sets this case, Mr. Idris, back before Judge Webster, and that would be on Monday, February 9, 2026 at 9 a.m. Monday, February 9, 2026, 9 a.m. before Judge Webster. You do need to appear by Zoom process before Judge Webster at that point in time. Next item of business, you've appeared this date. Any objection to Mr. Idris appearing next by way of OR bond? Mr. JRegier.
Your Honor, if the court is prepared to order that the defendant be subject to all standard conditions with special emphasis on no contact with any victims or endorsed witnesses during the pendency of this case, the state is prepared to recommend a $2,500 own recognizance bond. Pursuant to page 2 of the affidavit, this is a case where it is alleged that law enforcement identified multiple injuries on the minor victim's person, that the defendant admitted to law enforcement to the pit bull attacking the minor victim on public property, as well as to the same pit bull attacking another minor in the past. Additionally, this is a defendant who the state understands has a history of prior convictions, including at least one person misdemeanor and two drug-related felonies. So the state does respectfully submit that $2,500 is an appropriate amount.
Thank you, Mr. Aguirre. And Mr. Idris, further comment in regards to appropriate bond.
On the first time, the gentleman was trespassing on my property. He was in my yard.
Thank you, Mr. Idris. Based on your appearance here today, based on this being by way of summons and you being in compliance, the court does order an OR bond on your own recognizance. The court is not requiring you to post cash or to hire a surety. This would be on your own recognizance. I do believe that the conditions as set forth on the record by the prosecution are appropriate, and it would be a $2,500 OR bond. $2,500 OR bond. And the court makes inquiry to court security in regards to, do you wish to set up a appointment for posting of that bond?
We got him set up before the hearing, Your Honor.
Do you? Okay, very good. So we've already got that taken care of. And Mr. Idris, once again, your next appearance date is before Judge Webster on Monday, February 9, 2026, 9 a.m. That's by Zoom. Monday, February 9, 2026, 9 a.m. by Zoom. Mr. Idris, do you have any questions?
Now, Thor's been in custody for 12 days. The way I understand it, he only had to be there for 10. Is there any way I can go pick him up? February 9th is a long ways away.
Thank you, Mr. Idris. Court makes inquiry to prosecution. Mr. JRegier.
One moment, Your Honor. Your Honor, as this is currently a pending matter, the state would object to any release of evidence during the pendency of this case, as the state does consider it appropriate.
So that is a no to the release of the dog?
That would be the state's position, Your Honor.
All right. Thank you, Mr. JRegier. Anything further, Mr. Idris, in regards to release of the dog?
He does have a pen that's got a 6-foot gate or fence all the way around it, and there's only one way in and one way out, and that's through the house. That's typically where he's kept. But I just got home and I didn't know how long he'd been in the house, and I let him out to go to the bathroom.
All right. And you let him out on a lead or just no lead?
No lead. He usually just goes out and goes right there and it goes right back in the house. How he even seen her, I have no idea.
Okay, thank you. And court makes inquiry Is this in the city of El Dorado, Mr.
No, it's out in
Reed?
the country.
It's out in the country.
Yes.
Okay. And is there a county rule, a regulation against pit bulls in the county, Mr. Regier?
I would need the opportunity to research that matter further before I am in a position to respond. However, the state's position, as previously indicated on the record, remains unchanged.
Thank you. Where do you live, Mr. Idris?
My back property line is the city limits of Whitewater.
Okay. And does Whitewater have a city ordinance prohibiting pit bulls?
No.
Okay. Mr. Regier, if you want to check in regards to the status of the legality of a pit bull being returned to Mr. Idris, the court would appreciate the same. And Mr. Idris, I understand you're making a request for the return of the pit bull. Is that correct?
Yes.
Thank you.
The reason we even have the animal, sir, is I'm gone a lot and my wife is there by herself and there's absolutely nobody else around.
Thank you, Mr. Idris.
Your Honor, may I request a brief 5-minute recess?
Yes, court takes 5-minute recess, Mr. Idris.
Okay.
All right, we are back on the record, and the record may reflect the presence of the state by Mr. Regier, also the defendant, Mr. Idris. And announcements to the court, Mr. Regier.
Your Honor, upon further review, it would appear that the animal at issue in this matter was lawfully seized as evidence in this matter. Therefore, it is the state's position that KSA 222512 applies in this matter pursuant to the same, quote, under subsection A, quote, property seized under a search warrant or validly seized without a warrant shall be safely kept by the officer seizing the same until otherwise directed by the magistrate, unless otherwise directed by the magistrate, and shall be so kept so long as necessary for the purpose of being produced as evidence on any trial. The property seized may not be taken from the officer having it in custody so long as it is or may be required as evidence in any trial. As this matter has not proceeded to trial and disposition in this matter, the state respectfully submits that any earlier release of the animal at issue would be unlawful pursuant to the same statute.
Thank you, Mr. Regier. Mr. Idris, the court does find that I'm the magistrate in this case. So that means that I have the ability to make the orders in regards to the evidence. The court subsequently does order the dog Thor returned to you under the following conditions. You do need to properly feed, water, and care for the dog. You need to preserve Thor as evidence in the B misdemeanor case that is pending against you. You do need to maintain Thor. So without a court order, you cannot put him down. Okay. You must do your best, use your best efforts in regards to Thor. When you take Thor outside his area or your home, outside the fenced area, I think that you referred to, or the inside of your home, the court orders you to have him on a lead. You have to have him on a lead going outside of the home. So apparently the problem arose where there was a child allegedly, and Thor and the child had issues. Thor needs to be on a lead until further order of the court if outside the fenced area or outside of your own home. Do you have any question about that?
No.
Your Honor?
Okay. Yes.
The state would have it noted on the record that pursuant to the same statute, the statute specifically provides the property seized may not be taken from the officer having it in custody so long as it is or may be required as evidence in any trial. The state would respectfully request the court for a determination as to how the court's order is to be reconciled with that statutory provision. If the court finds that such an order can be reconciled with the plain language of the statute, the state would have its objections to the same noted on the record.
Court does note the same on the record. The court does find that pursuant to the statute as cited to the court by prosecution, it is subject to discretion by the magistrate, which I am the magistrate at this point in time, would be making the decision to return the evidence of Thor, the pit bull, to Mr. Idris, who was lawfully maintaining Thor in his fenced area and in the home. And the court has specifically ordered Mr. Idris to have Thor on a lead if the dog is outside of the house or the fenced area. He must have Thor on a lead in the county. So any question about that, Mr. Regier?
Nothing further from the state, Your Honor.
Okay. Mr. Idris, any questions?
No, sir.
And Mr. Regier, where and how does Mr. Idris pick up Thor?
Unfortunately, Your Honor, I'm not in a position to advise the court as to that information, as I am not privy to it.
Thank you, Mr. Regier. Could you please make inquiry as to the pickup of Thor?
I will put a note in the file, Your Honor.
Thank you. And can you do that at this point in time so Mr. Idris has the knowledge to go about picking up Thor?
Again, Your Honor, I would need the opportunity to make the necessary inquiries, but while on the record here today, I do not believe I am in a position to do so.
Okay, does the county have an animal control officer and a place where pets that are picked up outside or in the county that they are placed?
They took him out to Countryside Vet. Or Country Aid Vet, Pat Regier.
Country A?
Yes, Country Aid Vet.
Country Aid Vet.
Whitewater campus.
Say again, please.
It's Country Aid Vet in Whitewater, Kansas.
Country Aid Vet.
Yes.
And once again, that's Dr. Regier, is that correct?
Yes. Yes.
Very well. Well, the court would order that the dog Thor be returned to you, subject to the conditions as previously set forth. And also, what is the recommendation for the bond for Mr. Regier? Mr. Idris.
Your Honor, the state's information is that the court had already issued orders concerning bond in this case, specifically that bond be set in the amount of $2,500 on recognizance, with no contact with any victims or endorsed witnesses. Then, Your Honor, may I go off mic and off camera briefly?
Yes, please.
Thank you, Your Honor. Your Honor?
Yes, Mr. Regier.
After further conference with my colleagues, it would appear that necessary inquiries should be directed through the Butler County Sheriff's Office.
Okay, thank you. And Mr. Idris, the court would direct you to go through the Butler County Sheriff in order for the evidence Thor to be returned to you. So you need to make contact with the Butler County Sheriff for return of Thor to you. Do you have any question about that?
Where do I go for that? Just across the street.
You're currently located at the Butler County Judicial Building.
Mm-hmm.
Is that a yes?
Yes. Yes. Sorry.
Okay. Mr. Idris, you simply need to go back to the front desk, the security desk, go directly across the street. You'll go up Gordy Street, and the first door on the left is the Butler County Sheriff. And that would be the point you could make arrangements for return of the evidence under the conditions as previously set forth herein.
Okay.
And Your Honor, the state would renew its objections to this order on the record and would have its same objections noted on the record to this order.
Yes, the court does note the objection by the state to the court's order. The court has found that for the third time that it is sitting as the magistrate in the case that can exercise discretion in regards to the evidence.
Thank you, Your Honor.
The court does order Mr. Idris to maintain the evidence, the dog Thor, in the conditions as previously set forth on the record here today.
Thank you, Your
And
Honor.
Mr. Idris, do you have any questions about that?
No, I don't. I understand.
Okay, very well. Do you have anything further, Mr. Regier?
No, Your Honor.
Anything further, Mr. Idris?
Do I need a piece of paper or something to give to the sheriff to get this started?
I think that court security is there. They can give you whatever need be to get this started. They've listened to the orders of the court here today, and there should be someone there in the conference room with you on this Zoom hearing. So they would be able to provide you with whatever's needed. If they need to call the court, I'll be right here until 5 o'clock today.
Okay.
Mr. Idris, anything further?
No, sir. And thank you.
There being nothing further to come before the court, court is in recess. And Mr. Idris, you're free to go. Have a good day.
Thank you. You too.
Oh, this is all new to me. Yeah. Hello, Judge.
Mr. Pettis, good morning.
Oh, good morning.
Ms. Capone, do you have an opportunity to speak with Mr. Pettis, and are you prepared to proceed with his arraignment?
Yes, Your Honor. I'll just start by acknowledging I can see quite a history of incompetency findings, but at this time, I don't have those concerns. I will let the court know that Mr. Pettis has indicated to me that he's hard of hearing. So if he does have some confusion, that might be the source. But I did have the opportunity to speak with Mr. Pettis, advise him of his rights, and I do believe he understands them. We'll waive a formal reading of the complaint, and we're not contesting probable cause for today's purposes only. We'll ask the court to enter a plea of not guilty, and based on my conversation with him, I do believe he qualifies for court-appointed counsel. I will promptly follow up with the identity screening form.
Okay.
Thank you, Ms. Capone. Mr. Pettis, based on everything that your attorney just told me, I am going to waive formal reading of the criminal complaint, charging you with 1 count of theft in the 3rd degree. I'm going to find that there's probable cause to support the filing of the charge, but I'm going to enter a plea of not guilty for you at this time, okay? I'm also going to appoint Ms. Capone's law firm, the Horwath Law Offices, to represent you in this case as your attorney of record, so they will represent you in this matter going forward. The next thing I'm going to do is I'm going to hear from the prosecutor regarding his recommendation for pretrial conditions of release, and then I'm going to give Ms. Capone an opportunity to respond on your behalf. Mr. Graham?
Yes, Your Honor. The recommendation from the city is to release Mr. Pettis on his own recognizance with no criminal law violations, not to possess or consume alcohol or non-prescribed drugs, and to stay away from the 7-Eleven.
Stay away from the 7-Eleven? Why? What I do at the 7-Eleven?
Mr. Pettis, we'll talk about that in just a minute.
There's somebody that keeps saying this all the time. Excuse me for interrupting you. I'm like, hold on.
No, I know. Just go ahead.
I didn't come here. I'm shocked. I'm like, there must be like a duplicate, a twin or something, somebody that looks like me. I'm like,
okay, I'm going to ask you to be patient for a minute, okay? I want you to give Ms. Capone an opportunity to speak.
Your Honor, there'd be no objection to those conditions proposed. Mr. Pettis does have some history, but most of it is very old. Same with his warrant history. The allegations before the court are nonviolent in nature. So, given his presumption of innocence and presumption of release, we'd ask that he be released on his own recognizance. As I said, no objection to the conditions proposed by the city.
okay.
Okay, so Mr. Pettis, here's what we're going to do. And I don't want you to say anything. It's not that I'm not interested in hearing from you. It's just that I don't want you to say anything that could inadvertently or accidentally come back to haunt you, okay? Because everything that's being said here is being recorded. So I'm going to go ahead and go through the pretrial conditions of release with you. If you have any questions at all about this, when you're released, I want you to give your attorneys a call and they'll talk to you about it. That way you don't have to worry about everything you're saying being taken down and recorded on the record, right? You can then speak with your attorney privately. So I'm going to go ahead and go over the conditions with you at this time. First of all, you're going to be released. So you're going to be released from custody here later this afternoon. I'm releasing you on your personal recognizance. While this charge is pending, I want you to stay in contact with your attorneys at the Horwath law offices. Their telephone number and their contact information will be listed on the paperwork that the court officers are going to give you after your hearing this morning or this afternoon, okay?
Okay.
The other conditions that I want you to comply with while this case is pending, I want you to appear on time for all of your scheduled court hearings. Your next hearing in this case is on January 13th, 2026 at 1 p.m. here at the Lakewood Municipal Court. We're attached to City Hall and we're across the street from the Lakewood Town Center. The other conditions that I want you to abide by are I want you to have I want you to have no criminal law violations. You need to update the court if there's any change in your mailing address. And while this allegation is pending, you are not to have any contact with the 7-Eleven store in the city of Lakewood. Okay, so while this case is pending, no contact with 7-Eleven in the city of Lakewood.
Dang, I don't like that 7-Eleven too.
I know, but if you have any questions about that, you want to talk to your attorney. Now, once the case is over, that you might be able to go back. I don't know, but for the time being, you need to stay away from that store, okay?
Yes, sir.
All right, court has signed that order. Mr. Pettis, that will conclude your hearing. We'll see you back here on January 13th at 1 p.m. You can go ahead and let the officer know that your hearing is done, okay?
Okay.
You'll be released later today.
Okay. I got a question. Can I get it right back to where I was?
Mr. Pettis, that's a great question. I don't know the answer to that. I'm not sure.
Okay.
Okay? All right. Thank you, sir.
Thank you. Bless you. Take care.
Thank you, officer. And I believe that concludes our Nisqually calendar for today. Is there anything further from either council?
No, Your Honor, thank you.
Your Honor, thank you. Everyone have a nice Thanksgiving.
You too. Court will be at recess at this time.
Aye.